Good morning, everyone. This meeting is called to order. Mr. Trotman, has anyone signed up for public comment? Thank you very much. Good morning.
Good morning, sir.
How are we doing today?
Very well, thank you.
Good, good, good. No cases to reconsider under agenda item 3.
Correct, no cases.
Thank
Let's
you.
look at tax liability cases under agenda item 4. I think we have one tax case on docket 49.
Yes, sir. It's case number TD 22-029-0922. Commissioner Demerson,
I agree with staff recommendation.
Commissioner Alvarez,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation. No fair housing cases under agenda item 5.
Correct,
Under agenda item 6, we have no wage claim cases pulled for additional discussion.
correct. None pulled for additional discussion, but you should have received the wage claim short form dissent list for docket 49.
I move we accept staff recommendations on the remaining wage claim cases on docket 49.
I second the motion except for those cases of which I'm dissenting as reflected on wage claim short form dissent list for docket 49.
And I concur with the chairman's motion, except the cases on which I'm dissenting is reflected in the wage claim short form dissent list for docket 49.
Motion passes with the exceptions noted.
Thank you.
We'll move now to agenda item 7, consideration of unemployment insurance cases. Please proceed when you're ready.
Case number 2963561, Commissioner Alvarez.
The AT decision should be modified. The claimant established good cause for missing the AT2 hearing because his hearing packet was misdelivered to a neighbor, and he did not receive it before the hearing. I agree that the employer established good cause for missing the AT1 hearing due to a family emergency. Regarding the separation, the claimant was laid off when his assignment with the employer's client ended. When he was laid off, the claimant signed a document written in English containing an instruction for him to contact the employer, a professional employer organization, about further work. The claimant is a Spanish speaker and did not read the document. The claimant asked the client's representative if he needed to contact the company. The client representative told the claimant no, that the client would take care of all the paperwork. The claimant did not receive an instruction in Spanish informing him of his obligation to report to the employer for further work, and he was unaware he was required to do so because of the misinformation from the client's representative. The AT decision should be modified. The claimant established good cause for missing the AT2. The employer established good cause for missing AT1, no misconduct.
We should affirm the appeal tribunal decision. First, I do not dispute the claimant established good cause for missing the AT2 hearing. Next, I agree that the employer established good cause for missing the AT1 hearing as well. Concerning the job separation, the employer provided the claimant written notice of the requirement to contact the employer upon the completion of a work assignment. Although the claimant alleged that he was unaware of the employer's requirement, the record shows that the claimant signed the employer's policy on the matter. Since the claimant failed to contact the employer upon completion of the work assignment, the claimant's separation was voluntary and for disqualifying reasons under section 207.045I of the Act. As such, we should affirm the AT decision. The claimant established good cause for missing the AT2 hearing. The employer established good cause for missing the AT1 hearing, voluntary leaving.
Affirm the AT. Claimant established good cause for AT2. Employer established good cause for AT1. Voluntary leaving.
Short form dissent.
Yes, sir. Commissioner Alvarez.
Case number 3030311, Commissioner Alvarez.
The AT decision should be reversed. Based on the testimony from both parties, the claimant was not actually given an offer of work. The claimant was essentially being asked by the employer to restrict her availability to one school rather than be available to all employer schools. There is no evidence that she would be entitled to any additional work by agreeing to the employer's request. The employer admitted that she would be as needed in this new position, just as she was as a substitute teacher. Since there was no definite position that she would begin working in if she accepted the employer's arrangement, there was no offer of work, and she should not be disqualified. Moreover, even if this arrangement is considered an offer of work, since the claimant would have to restrict her availability with the employer to one school, she was potentially limiting her availability to work at other job assignments. This was therefore not a suitable offer, to the extent it was an offer at all. Reverse AT, suitable work eligible, no overpayment, void waiver.
The AT decision is supportable. The claimant's testimony established that she turned down a long-term opportunity for daily substitute teaching assignments in favor of continuing to work on isolated occasions for different school districts. Her stated reason that she was concerned she would miss out on opportunities if the other districts offered her assignments did not make sense. The district involved in this case basically guaranteed her new assignments every day, while the other districts offered her a day here and a day there so sporadically that she had no work at all for the 4 weeks preceding the offer in this case. Since the claimant was at fault in the overpayment, it should not be waived. Accordingly, the AT decision should be affirmed in all respects. The claimant refused an offer of suitable work without good cause, overpayment of $718, no waiver of the overpayment.
Reverse the AT, no suitable work, disqualification, no overpayment, void waiver determination.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 3064184, Commissioner Alvarez.
The AT decision should be reversed. The claimant was discharged because she was unable to submit her ADA paperwork by the employer's deadline. She was not able to secure a medical appointment in time. Despite her best efforts, the claimant was eventually able to see both her primary care physician and specialist. The claimant kept her supervisor informed of the situation. As the claimant provided documentation indicating that she was not yet released back to work by her doctor until several days after the date that the employer demanded her to return, the claimant was discharged for reasons other than misconduct connected with the work. Reverse AT, no misconduct, bill reimburse an employer, void adequate response.
We should modify the appeal tribunal decision. Although the claimant was aware of the process for submitting her ADA paperwork, she failed to submit the documents within the applicable deadline. This led to the closure of her claim. Due to the closure of her claim, the employer advised the claimant to return to work or face termination. Although the claimant alleged that she didn't return to work because of instructions from her doctor, the record suggests that the claimant did not present the employer with the medical documentation until after her termination. Since the claimant did not timely submit her ADA documentation or apprise the employer about her medical needs prior to her separation, her failure to return to work was mismanagement of her position of employment and was misconduct connected with the work. Hence, we should modify the AT decision, misconduct, reimburse an employer not billed, sever the adequate employer response issue.
Modify the AT, misconduct, reimburse the employer not billed, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3079155, Commissioner Demerson.
The AT decision is not supportable. The employer gave credible testimony that it did not receive the chargeback notice. Moreover, the chargeback notice was mailed during July 2020 when TWC and postal systems were still overwhelmed. Since the pandemic-related mail delivery problems could easily have caused the employer not to receive the notice, the employer's testimony about non-receipt is sufficient to qualify for the timeliness exception under Rule 32. In view of the technical difficulties experienced by the Texas Workforce Commission during that serious stage of the pandemic, the employer's protest should be considered timely. Accordingly, we should reverse the AT decision. The employer filed a timely protest, resubmit the case on the merits of the chargeback issue.
The AT decision is supportable. The employer's protest was filed over a year late. Although the employer has alleged non-receipt of the notice of maximum potential chargeback, the reason the employer did not receive it was due to their failure to keep an accurate address on file with the commission. The notice was properly sent to the address provided by the employer, and there is no good cause exception for the timeliness rules. From the AT decision, late protest to the notice of maximum potential chargeback, the determination charging the employer's account is left in full force and effect.
Reverse the AT, timely response to the NMPC, resubmit.
We will resubmit the case.
Case number 3104687, Commissioner Demerson.
The AT decision is not supportable. The employer gave clear, consistent, and credible testimony that it did not receive the chargeback notice. Moreover, the chargeback notice was mailed during May 2020, exactly when TWC and postal systems were becoming more and more overwhelmed. The testimony about the correct address for the employer is beside the point. If TWC used a legally correct address, the employer's testimony about non-receipt is sufficient to qualify for the timeliness exception Rule 32. In view of the technical difficulties experienced by TWC during the height of the pandemic, the employer's protest should be considered timely. Regarding the merits of the work separation, the employer's testimony showed that the claimant quit his job with the employer in order to accept another position. This is certainly a non-chargeable work separation. Accordingly, we should reverse the AT decision. The employer filed a timely protest, protect the employer's account from chargeback.
Okay. The AT decision is supportable. The employer's protest was filed over a year late. Although the employer has alleged non-receipt of the notice of maximum potential chargeback, the reason the employer did not receive it was due to their failure to keep an accurate designated chargeback address on file with the commission. The notice was properly sent to the address provided to the employer, and there is no good cause exception to the timeliness rules. Affirm the AT late protest to the notice of maximum potential chargeback. However, if my colleagues disagree with me on the timeliness issue, the employer's account should remain charged. The claimant quit a part-time job for another job with the belief that he would increase his weekly wage. Such a separation would not have disqualified the claimant had it not been for his late separation prior to filing his initial claim. As such, the employer's account should remain charged.
Reverse the AT, timely response to the NMPC, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3224680, Commissioner Alvarez.
The decision is not correct. The claimant quit because her newborn child had a health complication which required her care. The claimant informed the employer of the situation and attempted to work out a schedule that would allow the child to receive care. The employer declined the claimant's request for a schedule change. The claimant also spoke with her supervisor, who allowed her to take time, but she received discipline when she needed to take the time. Since the claimant's separation was due to a medical issue involving her minor child, I can agree to protect the employer's account from charge. Modify the AT, no voluntary leaving, no chargeback, MBI.
We should affirm the appeal tribunal decision. The claimant quit due to dissatisfaction with her work hours. Although the claimant's testimony suggested that her separation arose from the child's medical condition, in her previous statements to the commission, the claimant stated that she did not quit due to her child's illness. Instead, she quit because her manager was unwilling to accommodate her personal circumstances. Since the claimant quit because her manager would not change her schedule, the claimant did not establish good cause connected with the work to quit. Hence, we should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3228840, Commissioner Alvarez.
The decision is not supportable. Two new supervisors were insulting employees based on their race. The claimant reported the issue to HR and was told they were probably just playing around. After no action was taken, the claimant put in her 2 weeks notice explaining the situation in an attempt to get the matter resolved. The employer accepted the claimant's resignation immediately before looking into the matter. The claimant had good cause to quit due to the racism she experienced in the workplace and after attempting to address the matter with the employer without resolution. Reverse AT, no voluntary leaving, chargeback.
We should affirm the appeal tribunal decision. The claimant quit due to dissatisfaction with the employer's working conditions. Since the claimant quit without affording the employer a reasonable opportunity to address her concerns, the claimant's separation was a voluntary quit without work-connected good cause. As such, we should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 3235460, Commissioner Alvarez.
The AT decision should be reversed. The employer alleged that the claimant falsified his timesheets, and the claimant has denied doing so. The employer claims that the GPS records show discrepancies between the claimant's locations and his reported time working. No such records have been provided as evidence. The employer's testimony did not even provide specific dates or times that the claimant supposedly falsified. The employer has the burden of the proof to show by preponderance of the evidence that the claimant was discharged for misconduct. They have not met that burden in this case. Reverse AT, no misconduct, chargeback, void adequate response.
We should modify the appeal tribunal decision. The claimant was aware of the employer's policy, which dictated that falsifying company records could result in termination of employment. The claimant was terminated for misrepresenting hours on his time card. The record shows that the claimant did not apprise the employer about mistakes on the time card, nor rectify any errors with the employer. Since the claimant misrepresented his time card in violation of the employer's policy, the claimant's conduct was mismanagement of his position of employment. Hence, we should modify the AT decision, misconduct, no chargeback, sever adequate employer response.
Reverse the AT, no misconduct, chargeback, void adequate response.
Short form consent.
Yes, sir. Commissioner Demerson.
Case number 3238012, Commissioner Dimerson.
We should reverse the appeal tribunal decision. The claimant was employed on a contractual basis with the employer. The claimant requested release from her employment contract due to an alleged medical condition. Although the claimant provided medical documentation from months prior, the record shows that the claimant was released by a doctor to return to full duty work at the time of her request for release and eventual resignation. Since the claimant was not advised by a doctor to quit and because continued work was available to the claimant at the time of her resignation, the claimant did not establish good cause connected with the work to quit. As such, we should reverse the AT decision, voluntary leaving, reimbursing employer not bill, adequate employer response.
The AT decision is supportable. The claimant applied for unemployment benefits while she was on approved unpaid FMLA. While off work, the claimant met with HR to see if the employer could accommodate her work restrictions, but she was told there were no light duty work available for her position. The claimant was involuntarily separated from the employer due to her medically verified illness. The AT decision should be affirmed. No voluntary leaving, bill reimbursing employer.
Affirm the AT, no voluntary leaving, bill reimbursing employer.
Short form consent.
Yes, sir. Commissioner Demerson.
Case number 3272747, Commissioner Dimerson.
The appeal tribunal decision should be affirmed. The claimant was discharged for refusing to complete a task he had done in the past. The claimant alleged that there were safety concerns with the employer's request, but the claimant did not state any kind of specific harm or concern other than stating he felt the employer's task was unsafe. In fact, the most specific description of the claimant's concern came from an employer witness who stated that the claimant's concern related to clutter. The employer witness went on to state that the claimant was advised to move the clutter out of the way, and thus the claimant was given a remedy to his concern. Because the claimant refused to comply with an employer task that he had performed previously, his actions constituted mismanagement of his position of employment, amounting to misconduct connected with the work. We should therefore affirm the AT decision, misconduct, no chargeback.
The decision is not supportable. The claimant had been running one machine for the employer for most of his employment. The employer instructed the claimant to run a second machine at the same time. The claimant was concerned that it would be unsafe to do so and expressed his concerns to the employer. The employer suspended him as a result. When he returned, he met with the employer about the issue and, according to a statement submitted by the employer, complied with the instruction and ran both machines. At the end of the day, the employer discharged him because they thought he might intentionally hurt himself. Although the employer has alleged the claimant engaged in insubordination, the statements they provided show his discharge was due to their belief that he may hurt himself. The employer's belief that the claimant might intentionally hurt himself cannot be misconduct. Reverse the AT, no misconduct, chargeback.
Reverse the AT, no misconduct, chargeback.
Short form consent.
Yes, sir. Commissioner Demerson.
Case number 3304257, Commissioner Alvarez.
My last case, just to let you know. The decision is not supportable. The claimant is being held ineligible because she responded that she did not have gas money. If the claimant were simply not held ineligible, she would have received her unemployment insurance benefits and therefore have gas money. Holding the claimant ineligible and not paying her benefits because she does not have money is illogical and a poor practice. Since the claimant's only impediment was a lack of money and the payment of her benefits would have cleared that issue, she should be found eligible. Modify the AT, the claimant is available for work, sever availability issue favorable to the claimant.
We should modify the appeal tribunal decision. The claimant, through various documents submitted to the commission, specified that she did not have an effective mode of transportation due to her unwillingness to use public transportation and because she lacked money for gas. The claimant offered testimony that she was able to obtain transportation as of the date of the AT hearing. As such, the portion of the appeal tribunal decision which held the claimant ineligible for benefits beginning June 26, 2022, and ending August 6, 2022 is supportable. Next, the portion of the AT decision which held the claimant eligible for benefits under section 207.021 A4 of the Act should be severed, as this issue is not adverse to the claimant. As such, we should modify the appeal tribunal decision availability not eligible from June 26, 2022 through August 6, 2022. Sever the favorable availability issue.
Modify the AT, claimants available for work due to transportation, sever availability due to childcare, memo to investigate availability due to school attendance.
I'm in short form dissent.
Yes, sir.
Thank you.
And that was the last unemployment insurance case pulled for additional discussion on docket 49. You should have received the UI short form dissent list for docket 49.
I move we accept staff recommendations on the remaining UI cases on docket 49.
You want to state something before I second the motion?
Let me do that.
Yeah.
Okay. Sherry, can we go back to case 49? I want to make sure that we're solid on the final vote. So
Could you give me the case number, please?
the case number is going to be 3304257.
Okay, the very last case. Yes, sir. So the majority vote is claimant available for work, sever the other availability issue in the claimant's favor. And then you had short form dissented. Did you want to clarify?
Yeah, no, I'm fine. That's good.
Okay,
Chairman, I second the motion except for those cases in which I'm dissenting as reflected on the UI short form dissent list for docket 49.
I concur with the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 49.
Motion passes with the exceptions made.
thank you, gentlemen.
Thank you.
Thank you.
We'll take a short break. So agenda item 8, final rules for chapter 850 VR services, administrative rules and procedures, and chapter 856 VR services.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, I'm Rika Weintraub with the Vocational Rehabilitation Division. Commissioners, before you today for your consideration and adoption are final rule amendments to Chapter 850 VR Administrative Rules and Procedures and to Chapter 856 VR Services. In an open meeting on August 16th, the Commission approved proposed amendments to TWC's Chapters 850 and 856 to establish rules required by the Texas Labor Code and to clarify rule language. The proposed rule amendments were published in the September 2nd issue of the Texas Register for a 30-day public comment period. Public comments were received from 2 organizations. Staff reviewed and responded to the comments, and as a result of those comments, modified the proposed rules. 6 specific comments were proposed for TWC's consideration. No changes were made in response to 2 of those comments, both of which were related to financial needs tests. 4 changes were made because of comments. Staff removed language in 1 subsection on impartial hearing officer decisions, added language on the content of the individualized plan for employment, clarified that the customer is informed of post-employment services, and amended Chapter 856 to allow certain exceptions for MAPS rates. Additionally, staff conducted a 4-year rule review of Chapters 850 and 856 in accordance with Texas Government Code, and determined that the initial reasons for adopting the chapters still exist and that these chapters are still needed. Staff recommends adoption of the amendments to Chapters 850 and 856. Should the commission adopt these rules, staff requests the ability to make minor non-substantive changes to the document in order to comply with the publication requirements of the Texas Register and the Office of the Secretary of State. This concludes my presentation. I'm available to answer any questions that you may have. Thank you.
Questions or comments?
None here.
Rika, how long have you been, Rika's leaving, so. How long have you been with us?
7 years.
7 years at the agency, all in the adult education and literacy program?
The VR program.
Yeah, okay,
Yeah.
good. Welcome on board.
Thank you.
Thank you.
But Commissioner, you asked that question as if you thought maybe this was the first time she presented before the commission.
I did some,
Yeah.
is it?
Is this the first time you ever? presented?
Yes, this is my first time.
It is. I feel somewhat sad that I didn't prepare more questions for you. But we're gonna move on all the same. There's no further questions. Is there a motion?
Chairman, I move that we adopt amendments to 40 Texas Administrative Code, Chapter 850 and 856 as recommended by staff.
Second,
It's been moved and seconded. We're unanimous. Thank you.
Thank you.
This is agenda item 9, AEL Strategic Plan Progress Report.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Dimerson, and Mr. Serna. For the record, Mahalia Baldini with the Workforce Development Division. For your consideration this morning, we present the Adult Education and Literacy Plan Progress Report for fiscal year 2022. Rider 29 of the 87th Texas Legislative Regular Session requires that TWC submit a strategic plan progress report due no later than December 31st of every even numbered year. The most recent AEL strategic plan was approved by the commission in August of 2021, and it outlined 4 key goals and 17 objectives with numerous specific action items. The progress report as outlined in your notebook materials is meant to highlight some of the state's responsiveness to meet the goals laid out in the AEL strategic plan, including but not limited to commission approved state leadership projects that were deployed to support the plan's goals and objectives, as well as state level priorities to address specific commission initiatives like middle skills, family math literacy, and employer engagement projects. It also includes policy or programmatic changes implemented to support a better overall AEL system, coordinated efforts both within our internal TWC departments and divisions, as well as any coordinated efforts with other state agencies like the Texas Education Agency. It also includes some initiatives that are responsive to the last legislative session, like digital literacy and our expansion projects related to remote and distance learning for adult learners. Staff are seeking permission to make non-substantive changes to polish the report prior to submission to the Texas Workforce Investment Council, the governor, and the Legislative Budget Board as outlined in Rider 29. This concludes my remarks, and I'm happy to answer any questions you may have.
Any comments or questions?
None here, Chairman.
good progress. No other questions?
Is there a
comments?
motion?
Chairman, I move that we approve the TWC Adult Education Literacy Strategic Plan Progress Report for fiscal year 2022 for submission to TWIC, the governor, and the Legislative Budget Board.
Second,
It's been moved and seconded. We're unanimous.
Thank you.
Thank you. So agenda item 10, legislative proposals and capital exceptional items.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, Michael Brick, Governmental Relations. This morning, I'm presenting for your consideration TWC legislative proposals for the 88th Texas Legislature. These proposals have been submitted by the Fraud Deterrence and Compliance Monitoring Division. I will now lay out each proposal for consideration, and we do have division staff here with us today. They're available to answer any technical questions that you all may have. Beginning on page 4 of your packets, we have the proposal related to an eligibility requirement for ID verification. This proposal would amend the Texas Labor Code to state that among other eligibility criteria, an individual is eligible for unemployment insurance benefits only if they have verified their identity as required by the commission. I'm sorry, Mr. Chairman, would you like to vote on these as we go
You wanna
through?
vote on
Or
them individually or-
Yes, please.
All right.
Okay.
Comments or questions?
Yes, since our office has been working closely with Chuck and Jason, I asked that they make their way up here because I may have some questions for them if they're available. Thank you. Jason. So my first question is, it is my understanding that this proposal is simply to quantify the agency's ability to withhold benefit payments until an individual's identity is verified. Is that correct?
Yes, sir, that's correct.
It is not the intended that this proposal be a result in an increase in the number of individuals who are required to verify their ID. Is that correct?
Yes, sir, that's correct.
Okay. Those are the only questions I have. I do have a comment, though. I can appreciate the need to clarify the agency's authority to withhold benefits pending ID verification. And for that reason, I will not oppose this proposal. However, I caution that ID verification requirements should only be imposed on individuals where there are legitimate indicators of fraud. Any criteria used by the agency to determine risk should be narrowly tailored to target situations where fraud is likely, and care should be taken to ensure the criteria does not result in an unintended discrimination against any particular group. Further, our verification process must include a sufficient method for a person to verify their identity to provide equal access to UI benefits for all claimants. Thank you both.
Thank you.
None here.
Are you gonna? make the motion?
Yes, sir.
Okay.
My motion is that I move that we support this legislative proposal.
And this is one for the eligibility requirement by ID verification. Correct. Second.
It's been moved to second reading then.
Thank you. Next on page 6 is the proposal related to an Open Records Act exemption for TWC's fraud detection and prevention related information. This proposal would create an exception to the Texas Open Records Act to accept from disclosure TWC fraud related contracts, data, and protocols from disclosure under the act and the Texas Government Code.
Comments or questions?
None here, Chairman.
None.
The only thing we would be seeking to eliminate would be just simply things that spell out our fraud prevention measures.
Yes, sir. Yes, sir.
All right.
Correct.
Is there a motion?
Chairman, I move that we support this legislation.
Second.
It's been moved to second reading unanimous.
Thank you. On page 10 is a proposal related to providing TWC with bank freeze authority for fraud. This proposal would provide TWC the authority to recover unemployment insurance overpayments resulting from fraud by bank levy as a collection method of last resort. This proposal would also require rulemaking for the commission to establish a minimum account balance threshold that would preclude TWC from levying funds, for example, from the first $5,000 in an account.
Comments or question?
First question. Why is this threshold to prevent seizure of personal essentials regulated by the proposal to be determined by the commission rule rather than provided in proposed legislation itself?
Sir, we were responsive to your staff's request to include that as a rulemaking item so that the commission itself could determine on a regular basis what the appropriate threshold should be. That's why we went with the recommended approach of rulemaking.
Thank you, Chuck. Isn't such a threshold a fundamental part of a collection authority granted by this proposed legislation and something the legislature itself should determine.
At this point, I would defer to the commissioners about whether they would prefer to retain that authority. It's similar to authority in career schools rules where commissioners have the authority to approve set rates and things like that. But I would defer to the commissioners on this.
Chuck, so the first question I asked you is, was this threshold to prevent seizure of personal, would it be better handled by us or proposed legislation itself? And you said you met with staff. Can you let me know what date you spoke to staff and who responded back to you on that?
Yes, when we briefed your staff, and I'll have to check my calendar on the date, when we briefed your staff on these proposals, your staff, Jeanette in particular, specifically said, would it be appropriate to put this in commission rule to have the commissioner set this? And Jason and I both agreed that that was appropriate. That's why we amended the original proposal to include rulemaking.
Okay, thank you. Thank you, Chuck. Who would an individual who has had their accounts frozen erroneously or otherwise contacted TWC to rectify the freeze? How long would the process take to remove the freeze?
That would be TWC's Collections and Civil Actions Department in Finance. It would run exactly the same way that process runs for employer accounts that are currently frozen. Though that I believe that process is resolved within 1 day to 3 business days.
So 3 business days?
I would have to confirm with the Collections and Civil Action staff, but that's my recollection that generally it doesn't take longer than 3 business days to resolve erroneous freezes.
Thank you, Chuck. There are multiple scenarios in which TWC can and does erroneously impose fraud against innocent claimants as a result of ID theft. What protections, if any, does this legislation offer to ensure that innocent claimants do not have their bank accounts levied when fraud is erroneously imposed against them?
I would note that as requested by your staff, we included in the proposal that this is a collection action of last resort. If we're talking about an overpayment that would be collected, a fraud overpayment that would be collected through bank freeze, it would have reached finality and it would have actually gone through collection methods through Treasury offset programs. So every due process avenue that's available to claimants would have been afforded in this proposal.
Chuck, so I'm assuming that you and Jason spoke to the UI office and
Yes.
regarding this. Okay, any fiscal notes and all of that? Yes or no?
Yes.
Okay, just want to make sure. My comment, there are no protections in this proposal to protect innocent parties from an unjust bank account freeze. Also, the proposal does not provide minimum thresholds of funds for basic living expenses, but instead delegates that job to the agency. The legislature is in the best position to make that determination and also in most directly accountable to the people most affected by this law. I have no further comments. Well, you know what? I found one. I do have one more. Where in the actual proposed legislation does it state that this is a collection method of last resort, if you have that?
In your packet on page 10, line 16.
Thank you, Chuck.
Yes, sir.
Sure, Darcy.
No comments. I like the fact Wisconsin is at $1,000 and we're going to $5,000 here in Texas for proposing that. So, okay.
What other state agencies use this tool to collect?
State agencies, I would have to research that. I just know that TWC has specific authority in the UI law for this, but I would have to get back with you to see
So
about
this is
other
an
states.
existing statutory thing?
Yes,
Okay.
specifically for delinquent employer contributions.
Would this particular authority for claimants mirror the way we do this for employees?
Exactly the same. Yes, sir.
Is there a motion?
Yes, I do anticipate that we'll be getting calls in the near future regarding this particular agenda item. I will make a motion. I oppose moving forward on this proposal.
Is there a second? Motion dies for lack of second. Any additional motions on this item?
So I like to move that we approve the legislative proposal for this bank freeze authority for fraud. I think it protects us in a big way.
I'll second that motion.
Thank you.
Any further comment?
None here, Chairman, not for 10C.
I'll be voting aye, Commissioner Alvarez. Will you be voting yes or no?
I'm voting against it.
Voting no?
Yes.
Commissioner Demerson?
I made the motion. I'm voting for it.
All right, it's 2-1. Thank you, gentlemen.
Thank you. Next on page 14 is the proposal related to prohibiting an individual from filing a new unemployment insurance claim until any previous fraudulent overpayments and penalties have been repaid to TWC. This proposal would amend the Texas Labor Code to stipulate that an individual is not eligible to file a new claim for UI benefits until all overpayments and penalties that resulted from fraud have been repaid to TWC.
Comments or questions?
Yes, Chairman, my first question. In your analysis, to those who did this, you make the following statement. I quote, often a UI claimant who has committed fraud is able to file a new claim when their current benefit year expires and potentially commit fraud again. What data do you have to support this statement? And how often does this occur?
We don't have discrete data for that specific question that you're asking, but we do have experience with claimants that have committed fraud that come back in and have not repaid their fraudulent overpayment. For as an example, this is just anecdotal. When the commission reestablished 100% offsetting of benefits, a number of claimants that complained to me directly about that were individuals that were having their benefits fully offset to recover past fraudulent overpayments. So it does happen.
Chuck, would you say it happens a lot or seldom or rarely or?
I think anecdotally it happens because the number of fraud determinations and overpayments are low. It is a low number, but it does happen, and it's an integrity issue.
So is enough to justify this particular agenda item in legislation? Low number?
I believe is an integrity item. That's what I'm charged with by Mr. Cerna and the commissioners, is to oversee the integrity of the unemployment insurance system. And I see this as a key way to do that. Yes, sir.
Okay, so again, I think I stated, just for the record, the question is, how many people do you think commit fraud? Would you say in the last year, or even the last 5 years?
Yeah.
I'm sure you have that data.
How many people commit fraud?
Mhm. I mean, what is the number? If we were to say that,
I apologize, Commissioner, can you repeat that?
yes. How many commit fraud again? That was the question. How often does this occur and how many people commit fraud?
I believe the last numbers I saw from AD&M were about one claimant a day with a fraud overpayment comes back in and commits fraud again. And that there are approximately 90 to 100,000 with fraud overpayments out there that have not repaid them. And
How
one
many
of
again, Jason?
90 to 100,000. And if they were to file again and have their benefits offset, those are current employer taxes that are paying their fraudulently obtained overpayment.
Okay. Can I ask if this was part of the discussion paper, just so that we could, I mean, you can see why I asked the question. Was that part of the discussion paper?
I believe this was in some of the supplemental materials that we sent out.
Okay. You also make the statement that, in quote, when the UI claimant files a new claim in a new benefit year, this means that the employer taxes from the individual's new base period are repaying the individual's fraudulent overpayment. In essence, Texas employers are financing an individual's fraudulent attempts to steal unemployment benefits. Isn't it true that this individual qualifies for a new claim? It is because they have returned to work and rightfully earned those wages in employment.
They would have met eligibility factors if they were qualified for unemployment.
Okay. This proposal not only requires that the previous fraud overpayment be paid, but also requires that 15% penalty be repaid. The October 26, 2022 to November 12, 2022 demographics for UI claimants indicate that 12 of the 25 top filing companies or counties are in South Texas. Most claims include separations from temporary work services followed by oil and gas and PEUs. This proposal legislation adversely impacts minority communities and lower socioeconomic individuals by further adding to their financial burden and punishing them during a time when they are at most need. Those are the end of my quotes, my comments, and I appreciate you all answering the questions.
No comments.
So there's 100,000 claimants, we believe, receive UF benefits fraudulently that have yet to repay. Did I hear you correctly?
That's correct.
And so this proposal, should the legislature choose to adopt it, would create a scenario where someone who is verified to have committed fraud, this would prevent them from receiving further benefits until we either resolve the fraud claim or collect the money from the fraud claim.
Until they pay us back the overpayment. Yes, sir.
Who determines it was fraud?
It's an agency fraud determination based upon the 2-vote system that the agency has in place.
And so this would only apply to people whom we reasonably believe collected the benefits fraudulently.
This would only apply to final fraud determination. So if it's in the appeals
We
process,
investigated it, they've appealed it, they've lost all their appeals, and the fraud determination stands.
Correct.
That's correct.
It's final for all purposes.
Are there 100,000 of these because of COVID, or is that a normal number?
I think that's historic. That's the normal number.
this is currently in existence.
Yeah. This is not a COVID effect.
All right. Is there a motion?
I have I guess another comment that I'd like to make. Chuck, you made a serious allegation that you informed my staff of some of the things that I asked you. That's the reason why I wanted to stick around till today to be at this important commission meeting. It is my understanding, I've had multiple conversations with my staff and chief of staff, Jeanette De La Cruz, who you informed me made the statements that she did. And I've asked her repeatedly, I needed some clarification, especially when it came to these legislative agenda items that or proposals that you were bringing forth. So the reason I asked for you to be here is because I wanted you to be on the record on what you were stating. My recommendation to both of you or to staff is if you are going to be providing if you're providing this information, those numbers need to be in the report. According to what I'm receiving from staff, I can assure you what they're telling me is that you never stated what you did regarding the discussion you had with Jeanette regarding that this should be a commission issue and not so much legislative. So I'm just informing you that that's what she said, Chuck. I mean,
May I respond?
of course you can, because I'm going to ask if my commissioners are okay with it. I'm going to ask for the record that Jeanette also be allowed to deliver some remarks as well.
Yes, sir.
We're going to take a short recess.
Goodness.
Commissioner Alvarez.
So thank you. And again, thank you, Chuck and Jason, for being upfront and being to the front to be able to answer these questions. Again, these were just a little concerning to me because like I said, there was, I didn't receive that information back from staff. The questions that we asked, that I asked you from the dais were questions that I had for her. I had asked her to ask you all. And again, I think there's some differences on what the responses were. Just a recommendation, put some of those things, Jason, like the numbers 100,000 to 90 to 100,000, the number that you kind of pointed out in case the legislators, some of these things I know are questions that if I were a legislator, I would be asking. So I do appreciate both of you, your responses to the questions that I had. No further questions or comments.
Comment. I like the fact that we are, fraud's a big concern here in the state and in the US. And I like the fact that we are taking a proactive approach towards it, trying to get there. These are legislative proposals, and so if approved, there'll be further discussions on these things on a go-forward basis. But fraud is huge, and taking a proactive approach is the right thing, in my opinion.
Okay, any further comments?
None here,
Is there a motion?
Chairman, I understand that we all have a vested interest in fraud deterrence and detection. But I cannot support legislation that has no supporting data and does nothing more than penalize people who are already financially burdened. I would rather see this agency engage in real fraud deterrence and detection, focused on areas of high risk such as those identified by the Department of Labor, Office of Inspection General, memorandum dated September 21st, 2022, and participating in the Integrity Data Hub as outlined in the May 5th, 2022 Training Employment Notice 24 to 21, rather than engage in policies that do nothing more than punish the poor and adds to the poverty. So I vote against because there is insufficient data to support this proposal, and on its face does nothing to deter or detect fraud. It simply piles on someone who has already been punished. So my vote is against.
All right. Is there a motion to accept this?
Yes, I move to approve the legislative proposal for the prohibition on filing a new UI claim until repayment.
All right, I second the motion. I think we're on record.
Yes, sir.
I'm for. Commissioner Demerson, I believe, is for, since he made the motion.
And I
Alvarez opposes.
Yes, sir.
All right, thank you.
Thank you. Next, on page 18 of your packets is the proposal related to increasing the 15% UI fraud penalty. This proposal would amend the Texas Labor Code to increase the current UI fraud penalty to 50%, with the amount of the penalty above the federally required 15% going to the Special Administration Fund, or Fund 165, as it's also known, to fund TWC's fraud deterrence activities.
Comments or questions?
Chairman, my first question, how does this penalty compare to the penalties assessed against employers that failed to pay contributions due to misclassification or failure to report wages?
I would say this is not an analogous penalty to the situation you laid out.
Can you repeat that? I'm sorry, Chuck.
I would say that this penalty is not analogous to the penalties that you laid out, the employer penalties for misclassification. I would say, though, that our recommendation for this one is there is an employer misclassification penalty in Chapter 214. However, the proceeds from that penalty revenue do not go back to TWC to fight misclassification. We've recommended in this proposal that the revenue from this proposal be used for fraud prevention and misclassification activities.
How does this compare to fraud penalties in other states?
Jason.
This was in the median of what we saw from other states, that Texas is one of the very few that keeps only the federal required 15%. Other states are in the range of 65%, some are in 30%, and others have tiered step ups, which is, 25% for the first violation and 100% for the second. So we felt that the 35% was in the median of the states that we were able to review.
The only other comment I have is I oppose this proposal because we already have criminal provisions for that deter those who commit fraud. The penalty is a set amount that is not assessed based on an individual. Culpability circumstances of each particular case. Finally, the purpose of the penalty is to deter fraud, not generate additional revenue streams. That's the only comment that I have.
So, Jason, I did have a question, but I think you've already answered it. So 35% is kind of a medium of both, and so of some of the other states. And
That's correct. That was
Okay.
part of our analysis.
And then I think, does this also, the 50% sends a message? I would think
Yes.
we're also sending a message. We're at 15%, the lowest right now.
Exactly.
And so other states have already done that. That's where I was reading it. This also sends a good message. Yeah. Thank you.
Walk me through how someone gets to the point, what are all the processes that would have taken place for someone to get to the point where they would pay this penalty?
You take that one, Jason.
Certainly, this would be the same as a normal adjudication process where if our benefit payment control department detected the fraud, there would be 2 votes to find fraud. A determination would be issued. That 15% penalty, the current 15% penalty is part of that. This would be now the 35% on top of that. The penalty and the determination go together with appeal rights to the appeal tribunal, to commission appeals, to come before the commission, and through judicial review. So there are many ways in which due process concerns should be alleviated.
So any due process issues would be satisfied at the administrative level. They would have this particular accusation of fraud ultimately would be heard by the commission at some point.
Correct.
Yes, sir.
And then they would preserve whatever due process rights all Texans have through whatever remedy they
Judicial
might find
review.
through the courts. Yeah.
Yes, sir.
Yes.
Yes, sir.
Thank you. The penalty wouldn't be imposed until such time as all of those particular remedies had been exhausted. Is that correct?
Correct.
Correct.
Thank you. Any other comments or questions?
Again, I want to thank both of you for answering the questions. As you know, in my position, I want to make sure that we went through one of the worst times when we experienced the pandemic and some of the other circumstances that have taken place just in the last 7 years, whether it was a hurricane or other natural disasters. This is certainly important to me because, as you know, I don't want to assess additional penalties on any constituency. I mean, Jason, you used to work in our office, so you're very well aware of some of the responses that we would get or calls that we would get regarding this. And again, no one wants to be labeled as committing fraud. I mean, that's a big term, and that's not a good F word to have, right? So I just wanted to clarify some of those these legislative proposals that you were bringing forward, and I appreciate both of your responses back to the commission. So again, thank you for that.
Sir, can I respond? The point I would make about the penalty revenue generation is the Department of Labor does not really fund us adequately to conduct all the fraud deterrent activities that we need to take. And so we have to carve out a portion of our administrative UI budget for fraud activities, but that takes away from other work that assists claimants and employers and just sort of navigating the system, because 98% of the people that are in the system are following the law. They're not committing fraud, but the administrative costs of fraud deterrence really are taking away from other initiatives. And so this was just an opportunity for us to sort of put it back on the person that's committing the fraud to sort of help us with deterring fraud in the future. I hope that's helpful.
It is. I was just hoping that we could figure out another resource where we could get this funding and not go after those. I mean, we obviously don't understand their circumstances, and they were tough. I just want to make sure that if someone is legitimately put out of work, that he can apply for uninsured benefits, even if he has something pending. Sometimes the perception is that they're continuing to go on unemployment so they can pay their back taxes or pay whatever they owe us. And I just wanted to clarify that, that we're doing everything we can, and that you as an office, we're looking at other resources, because we don't want to penalize just the claimant.
Right.
What we're doing for the claimant, we also should do for the employers and everyone else, if I'm mistaken. And I just want to be on record for that.
All right, is there a motion on the side?
Chairman, the only motion I have is to oppose moving forward on this particular proposal.
Not a second on that, so I'm going to move forward that we approve the legislative proposal for increasing 15% UI fraud penalty.
I'll second that motion. So I'm in favor of that motion. I believe Commissioner Demerson's in favor of that motion. Commissioner Alvarez will show you as opposed.
That's correct. Thank you, Chairman. Thank you, gentlemen.
Next on page 24 is the proposal related to fraud provisions for ID theft. This proposal would amend the Texas Labor Code to allow TWC to issue a fraud determination and take associated collection actions against the individual who committed the ID theft when TWC can identify the perpetrator. This is not allowed under current law.
Questions?
What agenda item is this one?
Is this page 24?
Yes, sir.
Which agenda item is it? I'm sorry, I'm a little confused here.
I'm sorry.
F?
ID determination
Okay.
for fraud proposal.
Okay,
I'm sorry,
great,
sir.
Thank you. So additional questions. How often is TWC able to identify the imposter?
Jason.
Not that often, but there are circumstances in which we do have, usually it's a family member or a neighbor who is helping someone file. And currently, we cannot establish an overpayment against that individual that committed the act of stealing someone's UI benefits. And this proposal would allow us to do that. It would also allow us to have administrative recourse or determinations against criminal schemes that we work with DOLOIG on. And when there is a prosecution and conviction, currently there is, there's a verdict, but there's not any administrative recourse that we can have. And this would allow us to do that. And one of the key things that I would mention is that with these schemes, when we are, and unfortunately it takes a while for some of them to unravel, but when we are able to identify them, sometimes the statute of limitations has occurred criminally, but that would not prevent, but with this proposal, we'd be able to handle that administratively and still have that overpayment. And like I said, unfortunately, ID theft is rampant and we've done a good job containing it through our controls, but we can't always identify the individual. But when we can, we want to be able to take that recourse and make sure that the person who did perpetrate the fraud is the one punished.
So when I asked you, how often does this take place? You said not often. It
It's-
started off by saying, well, not often.
It's not all that often, but we think it is important that when we do identify it, we be able to have the overpayment and the fraud attributed to the individual that did the act.
Thank you. In the latest report on fraudulent identity theft from March 1st, 2020 through August 31st, 2022, a 30-month period, only 0.10% of total benefits were paid to confirmed imposter claimants, or less than 10,307. So how much money do we anticipate will flow to the unemployment trust fund with this low number?
I'll be honest, I think the amount is probably negligible, but I would just counter that this is an integrity issue. Our current statute doesn't afford us the authority to issue a fraud determination when we know who committed the ID theft. This is just basic common sense to me. That we undergird the statute to allow us to issue a fraud determination when the facts bear out, when we can identify who those people are.
Will these imposters be given appeal rights? If so, I do not see a fiscal impact analysis to the appeals and commission appeals division in your fiscal impact.
Yes, these determinations, like any other determination, afford appeal rights. As we've discussed, the volume is such that we do not believe it would be an appreciable impact on appeals or commission appeals.
With these imposters, okay, so I mentioned that. So you, again, Chuck, you and Jason have had an opportunity to speak to the UI division about all of these legislative proposals.
Yes.
Okay. No further questions, Chairman.
None here, except that I appreciate the fact that we're continuing to try our best to clamp down on fraud. I mean, I think that's the way that we should be headed. And again, it gets back to an integrity issue. Won't receive a lot of funding from here, but there's no a fiscal implication to the state is what I'm seeing here as well, but it gives staff the ability to take care of business. So,
Correct, sir.
Third motion.
Chairman, I vote to move this one forward as a legislative proposal on behalf of the agency.
yeah, referencing the fraud provision for identity theft, I second that motion.
Been moved and seconded.
Next on page 27 is the proposal related to modifying the definition of last work for an initial claim. This proposal would amend the Texas Labor Code to modify the definition of last work and person for whom the claimant last worked to mean the claimant's last employer with a liable TWC tax account.
To those here, how will individuals who last worked as an independent contractor be able to file claims? And how will the appropriate separation be analyzed if they are no longer able to name their independent contractor work?
Under this provision, we would go back to the last employer in that has reported wages to the individual. To be eligible for a claim monetarily, there has to be sufficient base period wages paid from a covered employer. So anybody that would be eligible monetarily for a claim would have to have an eligible covered employer in their past.
Okay. How will individuals who are being misclassified be able to file a claim?
It's the same process as currently. If an individual files a claim and their last employer or previous employers have not reported wages and they believe they're misclassified workers, there's a tax investigation, and then that issue is resolved by the tax department and then through the Rule 13 process.
So how will the correct last work be analyzed?
Again, in order for the claimant to be monetarily eligible, there has to be a covered employer in the claimant's base period that we would go to the most recent covered employer to determine that job separation.
And we have the manpower and all that to do.
That's currently what we're doing now, essentially. Under the current process, an individual is able to name somebody that they worked for 30 hours in a week. That doesn't have to be a covered employer. So essentially the mechanics of that, the UI claims examiner, if they can't find that entity as a covered employer, they're just creating a tax account, sending a notice of unemployment to that individual, and whether or not that entity replies or not, most likely they won't because they have no vested interest. But that's how the current process works.
So clarify some, are claimants not parties to tax investigations, or are they?
That is correct. Claimants are not party to Rule 13 hearings.
So how will claimants know the process?
For their UI claim, they'll receive a determination from TWC regarding the validity of the last employer.
Okay. If your proposal is to investigate the last separation from an employer with a tax account and not the actual last separation. So the question is your proposal to investigate the last separation from an employer with a tax account and not the actual last separation?
Our proposal is to try to find the last employer. Hopefully it is the last covered employer. The problem with the current system is, as I explained, an individual can name somebody that they worked for only 30 hours in a week. And that is the controlling job separation. And it's very easy for individuals to avoid getting out from a disqualifying separation that occurred a week before, 2 weeks before. And we see this not on an infrequent basis with our own employees that sort of set themselves up as being a last employing unit for anybody that needs that help to qualify for a claim.
Okay, thank you, Chuck. If a misclassified individual is able to initiate an investigation by the tax department for unreported earnings, How would they be able to appeal a ruling regarding these unreported wages if they cannot file a valid UI claim without naming an employer with a TWC tax account?
Sorry, can you clarify that for me,
Yes,
please?
so let me just read again. If a misclassified individual is able to initiate an investigation by the tax department for unreported earnings, how would they be able to appeal a ruling regarding these unreported wages if they cannot file a valid UI claim without naming an employer with a TWC tax account?
I believe that the claim is taken but pended during the investigation of the wage credits. If and that determination on whether or not they should be awarded those wage credits is an appealable determination. And so if ultimately it's decided that it's not a valid claim because the wages are not due, that's still also appealable.
Okay, so how can a claim be taken if they cannot name the employer?
The claim is pended during the wage investigation.
So we're taking the claim, we're taking who they're naming, but as Jason indicated, there's a wage investigation which results in an appealable determination.
How would a claimant who last worked for an employer in another state who does not have a TWC tax account file for a claim naming their last work?
Our recommendation is to remove the current language with respect to using an out-of-state employer.
If the employer does not have a tax account, how would they be able to name them? Again, I'm asking that question.
Can you repeat
Yeah.
the question?
If the employer does not have a tax account, how would they be able to name them, the employer, their last employee?
Well, under our current system, as I say, the claimant names who they last worked for. If that is not a covered entity that we can find, then TWC staff creates a bogus tax account and moves forward under this proposal. We would find the claimant's most recent liable employer that reported wages.
That's
Thank you.
correct. If they're going to be filing from using wage credits from another state, they still have to have Texas wages and create a
Right.
combined wage claim. So they would still have an LEU, which would be the Texas employer with the liable account. And just one thing I wanted to add
Yes, sir.
is that not only is this an integrity legislation or proposal to prevent fraud from benefits fraud, but also on the ID theft side. During the pandemic, we discovered that it was very important for us to have an employer that could provide a response. So that what PUA showed us is that when you don't have any employer that you can get a response from, it's much more difficult to stop fraud early on in the process because we can't get that response saying this person still works here or something of that nature.
I can appreciate the efforts to try and curb fraudulent claims, but this proposal will have a significant detrimental impact to many Texans who would otherwise be eligible for benefits. Individuals who last worked as independent contractors or who were misclassified by their employers might be completely unable to file claims as a result of this proposal, with no clear avenue to rectify the situation. Although possibly a claim could be filed naming an old employer, that employer would not be the last separation relevant to the claim. Even if the claimant could get the correct final work listed, the wrong separation would have already been investigated and subsequently substantial agency resources expended to adjudicate an older irrelevant separation. Many legitimate claimants will be significantly delayed in receiving their benefits. I fear this proposal will not noticeably reduce fraudulent claims, but instead simply delay or possibly completely prevent many legitimate claims from being filed. For these reasons, I cannot support this proposal.
So this, as I'm saying, it tightens the process right now, basically moving away from individuals working 30 hours and saying this is who they worked for and getting it to a defined covered employee type situation there where they
That's
have a
correct.
tax account that's set
Correct.
up, and that makes it easier for us to track from that point. And so, okay. No other comments or questions?
in layman's terms, describe to me what we're trying to prevent.
So in layman terms, I started at TWC in 2004. My very first assignment was this legislative proposal to fix the current process. When I started at TWC, you could name any entity as an employee. There was no, they did not have to be a covered employee. It just could be any entity. And so as an integrity measure to avoid this issue of purging a disqualifying job separation, we added in 2011, I believe it was, this 30-hour requirement, so that an employee, so that there had to be some connection between the claimant and their jobs, and hope we assumed that the employer would probably be a covered employer as well. But as we process this enhanced integrity change and seen it in action, our determination, especially after what Jason laid out with respect to PUA, is that the current 30-hour rule is not sufficient. There's not enough connection to a claimant and somebody that they might have worked for 30 hours. And in our analysis of other states, while other states don't specifically have this state that the last employer has to be a covered employer, they put monetary and time restrictions on it that sort of make it a de facto last employer. Did that answer your question, sir?
Yeah, sort of. So this is a basic eligibility question.
Yes, sir.
Your base period is defined as what?
The first 4 of the last 5 quarters.
Okay. So if someone's been an independent contractor the entire base period, but then they work for somebody 30 hours total,
Right.
4 days,
Mhm.
they would attempt to file a claim. Would they be awarded benefits?
No, sir, they would not have base period wages because they didn't work for a covered employer.
So an independent contractor who maybe the first quarter had worked for a taxed employer and then becomes an independent contractor, they would have some benefits due to them because of the 1 quarter that they had in the base period and where taxes have been paid on it.
Correct.
Do independent contractors or self-employed persons, do we believe they use this 30-hour rule to try to claim eligibility when they wouldn't otherwise have been eligible?
I would say anecdotally, no. I would say generally the 30-hour rule is used by somebody that knows they have a previous disqualifying job separation, probably for misconduct or quit without good cause connected work to do so. And they're using the 30-hour employer to purge that disqualifying job separation.
Their motion.
Chairman, before you vote, I'd just also like, since that was a great question you asked, Chuck and Jason, would it be possible to have additional input via memo from UI on how this would actually work? Maybe you could send that to our offices and maybe attach that to any of the paperwork that you have.
Yeah, absolutely. We're currently working with UI staff to operationalize this, how this would work.
Thank you.
Is there a motion on this side?
Yes, Chairman, I object to moving forward on this proposal.
Yeah, it's not a second, but I'd like to move that we approve the legislative proposal for modifying or redefining / work for initial claims. Sorry.
A second, Commissioner Demerson.
Okay.
Any further discussion?
None here, Chairman.
I'm assuming we're showing Commissioner Demerson and myself is in favor, and Commissioner Alvarez is opposed. All right.
Yes, sir.
Yes, sir.
Okay. Next on page 31 of your packets is the proposal related to unemployment insurance and reemployment services and eligibility assessment, or RESEA. This proposal would amend the Texas Labor Code to expand claimant participation in certain reemployment services such as RESEA, regardless of the claimant's likely to exhaust benefit score, and also allow flexibility for claimants to be scheduled for successive RESEA services.
Comment your question.
Is this proposal intended for all claimants to participate in reemployment services or some subject to claimants? Is it, the other part of it, is it only a subset? How would how will staff determine who should participate? Is this not with the RESEA score?
So we would work with our workforce board partners, determine their capacity to serve, to call in claimants. Our RESEA grant has gone up exponentially since we first became eligible. And we pass those grants on, as you know, to our workforce partners to run the RESEA programs for us. And we would work with them to ensure that they're calling in claimants that they have the ability to serve, but not calling in so many claimants that they know they can't serve them, but creating an artificial ineligibility. If that's what if that was your point.
Thank you, Chuck. The agency has contracted with the Public Policy Research Institute at Texas A&M to evaluate the RESEA program to determine best practices to scale across Texas. Why is this proposed legislation offered before the completion of this study?
As we mentioned in the proposal and many oh, okay.
Good morning, Commissioners, Mr. Cerna, Courtney Arbor Workforce Division. I can help with that one. Chuck, I
Yes,
certainly
please.
didn't mean to take the mic.
Oh, no,
but I'll help.
please.
That is part of the new RESCA requirements. Department of Labor has been very clear that we need to use evidence in our decision-making on how we operate this program, the way we conduct outreach and the services that are provided, although there are some services laid out in the regulation. This change allows us to call more in, so more claimants would have the benefit of the services provided. And you're right, Commissioner, as that evaluation is completed and we make changes based on those best practices, this larger number of claimants will be benefiting from what we learn along the way.
So is this study going to be completed before we submit the legislation?
It would not be completed, no. It will still be underway. I'm not sure of the date that final report will be in, but we're seeing this as two separate actions, allowing more to benefit from the services, and then that will inform future service provision.
Thank you. Thank you, Courtney. Thank you, guys. No further questions, Chairman.
None here.
So are we currently spending all of our RESCA money each year?
We are not currently spending all of the funding.
What percentage would you estimate that we spend annually?
Oh, I should have that number and I'm not going to have it. I will tell you that last year to this year, the amount that we distribute to boards went up from something like 11.6 to 16.8. So the amount is increasing. I'm not going to be able to tell you on the spot the percentage that has gone unspent, but I will tell you that several states are facing that and looking for ways to serve more. We just received notice from Department of Labor this week that states who are ramping up in whatever ways we can have an opportunity to apply for additional funding. So we're all working to serve as many as we can.
What does the RESCA program provide for someone who's receiving unemployment insurance benefit?
The stated goal of for the program with Department of Labor is to help claimants return to work more quickly. And so in that, the board's outreach for an initial orientation, and then there are a number of mandated services for participants, such as job referrals, help with a resume, the development of an individual development plan, which is basically helping them to establish the path to get back to work. And that may include training or support services. They're co-enrolled with other programs where there is a need. Those are just some of the examples, and job leads, if I didn't mention that, job referrals.
And so the RESCA money we distribute to the boards on some formula, I'm sure, since we have formulas for everything. And the board then takes that money and uses it to provide one or more of these services to people who qualify. Is that correct?
That's correct. The funds are primarily for staffing. This is one of the programs where it's very intentional on staffing to the degree you need so that you have enough people to help with those mandatory services.
And so right now, who participates in RESCA?
Right now, the participants in RESCA are those who are outreached, are those who are above what is called, and this, Chuck, is where I'll let you jump in. There's a cutoff score that is used, and we're limited now by that. So we can go no lower than the cutoff score in outreach, which leaves a lot of people without those services.
As required by federal law, all states have to have a claimant profiling system that uses characteristics of the claimant, the nature of their last employment, et cetera, to determine what their likely to exhaust benefit score is. And for our RESEA purposes, we can only call in those claimants that are determined likely to exhaust benefits, because those are the claimants against whom we can assess an ineligibility for not participating. Essentially, what this proposal does is allows us to call in more individuals for RESEA services, regardless of what their likely to exhaust score is.
Any further questions?
Chairman, you brought up some good points. I'm just curious, have we received input from the boards as far as our capacity? Have we had this discussion with the boards?
We do talk regularly with the boards, because the dollars of this program continue to increase and DOL continues to tell us that it will be, it's now a permanent program with ample funding. The boards understand that they would be funded to meet the need. Some already would be able, with the current capacity, to go to expand their outreach should this legislative change pass. Others would probably need additional staffing.
Thank you.
The only other thing I would add is
Yes.
that, as Courtney mentioned, and I alluded to, and it mentions in the paper, Department of Labor has been saying they made this a permanent program in 2018, RESEA, and they've been talking about having all claimants participating in these services because of the increased funding. If that were to happen, we would be here with this legislative proposal anyway, because it raises a conformity issue with federal law. So that's another reason, is this preemptively takes care of a potential future conformity issue. And this, the last thing I would say is your packet is a little bit outdated. On page 35, we give specific or some examples of legislative proposals. The Department of Labor actually responded to us yesterday. They said our proposal was confirming, and either one of these language choices is fine.
Do people who participate in RESEA, do they get off of benefits faster than people who don't?
Yes, sir, they do. And that's the intent of the RESEA, and that's why it's tied to claimant profiling. Profiling occurs at the claimant's first payment. And so if you can get claimants into a workforce center, into intensive RESEA services quickly, then that reduces the length of the spell of unemployment insurance duration. And Department of Labor has data that shows duration. The last I saw was approximately 2-week duration for participants in RESEA, generally speaking.
Mathematically, I think going back to work is financially more sound for a Texan than trying to remain on unemployment insurance.
Absolutely.
It pays more. I don't know very many scenarios where it would not.
Unemployment insurance is designed to be a temporary stopgap measure, approximately 40% of what your previous working wage was.
Do the boards, do they try to match services to the employee? I mean, so if you're dealing with someone and perhaps it's just an issue with not being able to know how to find a job, do they work with them in terms of using technology to find jobs, or is it a training day scenario where we pair up with somebody who can show them the ropes and how to do things in that particular thing? Do we match it to them, or is it just a menu of items that we let them pick from? How are we doing that currently?
When an individual attends that orientation and then starts to work one-on-one with the RESEA staff, they go through that individual development plan. That is where most of what you're talking about occurs, where they look at the education and the work experience of the person and the occupation they were just laid off from, to see if it looks like they need to switch gears. They'll then offer other opportunities, short-term training through one of those other programs, the metrics online courses, anything else they've procured. But it's really in that development plan phase where they look at the past and then to the future to see how to help customize.
And one of the key services that they offer is work search review. The counselor will sit down with the RACA claimant and go over their work search log to figure out if it's effective or not. And that's, like I said, this is designed early in the process to get the claimant reemployed. And so if we can redirect their work search to either they are going to go back to their previous employment or they're not. If they're not, how do they go to some other employment? That's a key component of the RACA services.
Are there still about 550,000 job announcements, job vacancy announcements pending in Texas?
I don't know the exact number, but there are plenty of jobs for anyone and everyone.
Last I looked, which was about
Yes.
2 weeks ago, there was 550 job vacancy announcements, and there was about 550 people receiving unemployment insurance benefits. It strikes me that additional training might be the answer to that equation and give us some opportunities to do that. Any further questions or comments?
None here,
Is there
Chairman.
a motion on this item?
Yes, Chairman, I will vote to move forward with this legislative proposal on behalf of the agency.
One second.
Been moved and seconded. We're unanimous. Thank you.
Okay, thank you. Finally, on page 36 is the proposal related to child labor appeals. This proposal will amend the Texas Labor Code to provide an additional level of appeal to the commission in child labor cases, which would be consistent with the appeals processes for wage claims and unemployment insurance claims appeals. The proposal would also make clarifying amendments to the Texas child labor law resulting from sexually oriented business bills enacted during the previous legislative session.
Again, I want to thank both of you for helping me clarify some of these questions that I have. No further questions.
Nothing here.
Is there a motion on this item?
Chairman, I move that we support this legislation.
Second that motion.
Been moved and seconded. We're unanimous. Thank you.
Thank you very much, commissioners. This concludes my presentation.
Agenda item 13, local workforce development board nominees.
Good morning, Chairman, Commissioners, Mr. Serna. For the record, Cherie Dudley with the Workforce Development Division. Today for your consideration, we have Workforce Board nominations for Borderplex, North Central Texas, Tarrant County, West Central Texas, Permian Basin, and Rural Capital Area. Staff recommends approval on the presented nominees, and I'm here to answer any questions you may have.
Any comments or questions?
None here, Chairman.
May have some questions for Mr. Bobby Gear, but no. We're good here.
That's a fair position to take. Is there a motion on this item?
Yes, Chairman, I move to approve the board nominees for Borderplex, North Central Texas, Tarrant, West Central Texas, Permian Basin, and Rural Capital Area.
Second.
It's been moved and seconded. We're unanimous.
Thank you.
Thank you. This is agenda item 14, revisions to WIOA funded online training and certification initiative.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, Mr. Serna. Ben Holt, for the record, Ben Holt, Workforce Development Division. On September 21st, 2021, the Texas Workforce Commission approved a training and certification for in-demand and targeted occupations initiative. TWC staff have identified two interconnected challenges to this program, and they're seeking a commission's approval to revise the directive. The program was to procure online training with an emphasis on industry-based certifications. After review and a procurement, we have determined that there is a lack of industry-based certifications for hands-on work, such as healthcare and manufacturing, which were specifically identified, that are available fully online. And that our experience with our existing online training provider found that certifications that were not industry-based and sought by employers were not being pursued by participants in the existing online training service. As such, staff recommend a change to the initial directive to remove the requirement for online certifications and instead make online certifications an additional component that may be offered if the vendor has a selection of online certifications relevant to high demand jobs in Texas. and then to remove an emphasis on specific trainings for high demand jobs and promote online courses in a variety of job skills that are in demand in Texas. This concludes my presentation. I'm happy to answer any questions.
Any comments or questions?
None here, Chairman.
None.
Motion on the side.
Chairman, I move that we modify the training and certifications for the in-demand and targeted occupations initiated as follows. Online certifications are no longer required to be offered, but are allowed to be offered if available. And the initiative now emphasizes an in-demand job skills in Texas rather than specific training, as recommended by staff and described in the discussion paper.
Second.
Yeah, it's been moved second. Is there any additional legislative report?
I think we do have a legislative report. He didn't have enough time up here. Wanted more time.
Glad for punishment.
Good morning again. It's still morning, right? Good morning, Chairman Daniel, Commissioners, Mr. Cerna. Again, for the record, Michael Brick, Governmental Relations. As you are all aware, federal government funding is currently set to expire on Friday, December 16th. Congressional leaders are still working out the details of a funding measure to extend government funding beyond that date. And as an agreement has not yet been reached, congressional leaders have been expressing support if needed for the possibility of passing a short-term continuing resolution beyond the December 16th deadline to give them the appropriate amount of time to finish their work on a larger funding bill and preventing any possibility of a government shutdown. Regarding the Texas legislature, this Friday, the Senate Committee on Criminal Justice has requested that TWC testify at their hearing on a panel with the Texas Department of Criminal Justice, the Texas Department of Licensing and Regulation, and the Windham School District. The committee has asked the agencies together to provide an update on their collaborative work on reentry programs for offenders, and Courtney Arbor will be testifying at that hearing on behalf of the agency. And just in case anybody wasn't keeping track, just a reminder that the 88th Texas legislative session will begin on Tuesday, January 10th at 12 o'clock noon. That concludes my remarks. I'm happy to answer any questions.
Any comments or questions?
No, thank you.
None here.
Thank you.
Very brief statement expressing my personal as well as staff's appreciation for Commissioner Alvarez's tenure as our commissioner representing labor. We've appreciated working with the commissioner and his staff on initiatives, though sometimes contentious, most of the time very successful. And we appreciate all the commissioner's support and wish him well in his future endeavors. And that's all I have, Mr. Chairman.
Right. Any other business come before the commission?
I just have one thing I'd like to say regarding maybe some policy, but other than that, and then after that, maybe a personal remarks. The HB 619 Early Childhood Workforce Strategic Plan presents this agency with a significant opportunity to address the current child care staffing crisis and articulate solutions to the legislature that can act on the increased investments in our state's early childhood educators. I hope that this agency seizes this opportunity to set a bold vision for early childhood workforce. That's to staff. On a personal note, as you know, last week I indicated, or I informed everybody that that I would be stepping down on December 15th. It has been a pleasure to work with each and every one of you as a team and as an equal. I hope that that our office made a difference in the lives of those that are less fortunate, as I know what it's like to be less fortunate. I think last time I had an opportunity to thank Gabby. Gabby was part of the process of being appointed. Taking a guy from South Texas and giving him the opportunity of a lifetime to change and to make a difference in the lives of so many people that are unfortunate and have circumstances, or as Jeanette de la Cruz says, life happens, has been extremely so gratifying. And I'm so grateful to Governor Abbott for selecting a first generation Hispanic individual from the South Texas border, just miles away from the border wall, to represent this great state, and especially the division of the Texas Workforce Commission, specifically representing the interest of those in labor. To my union comrades and those, my brothers and sisters that have done amazing work in the front line. I'm so grateful to folks like, I can't even think of their names right now, but like Wayne Lord, and some of the other folks who represent organized labor and Joe Cooper and them. I'm so grateful that when early on, I knew nothing about what this position was going to be asking of me, but they were such good teachers. And of course, I had two commissioners that I listened to for the first time, like Ruth Hughes and Andres Acantad, that I learned a lot from, and I continue to learn with the commission that we have here today. I'm so very grateful for everything afforded the opportunity to represent each and every one of you. It's sad that I'll be leaving, but you know, the things that I have learned along the way are just so impactful, and I will continue doing that. It's just at a different capacity. You know, one of the reasons that I just decided not to re-seek another term was because I felt like it was time for me to spend some time with my elderly father, who's in great shape, will be 81 in a couple of weeks, and I just felt like it was time for me to spend a little bit more time with him and with family. But as I've mentioned to many of you, I've always had family. You all were always my family, and so I hope I always treated you all like equals. And I'm just so grateful again to you all for allowing me an opportunity to represent this position as a commissioner representing labor. I've learned so much. I carried my picture of my mother at every commission meeting, and so I wanted to just show that. I lost her 20 years ago, but she always was with me when I was up here. And then, of course, I want to take this opportunity to thank my staff, Jade Ibarra, who has a smile from ear to ear, Elena Zachman, who's been a jewel to the office, Holly Aspen, who's been incredible, and today was her first day as lead attorney which was one of our best meetings. So thank you, Ashley. Holly. James Sutton, who's been super wise and very smart. Brent, who's taken the lead as our lead attorney for the agency. Brady Akers, who just finished his master's first semester at UT. And of course, none of this would have been possible if it hadn't been for the true commissioner of my office, and that's Jeanette De La Cruz. So I'm so eternally grateful for everything you've done. So with that said, I'm very happy to just inform you that this will be my last meeting. I think next Wednesday is my last day here. And Aaron, you have been a friend of mine. It's unfortunate that we couldn't spend any more time together, you know, going to eat at Polvos with your staff and chewing out on those tortillas until we couldn't eat anymore. And of course, Chairman, I appreciate working with you the last couple of years. So I certainly have learned a lot. And so I am very grateful to finish my time here with the commission with both of you here. So I have no doubt that, as I mentioned last Tuesday, that you will support the interest of the next commissioner representing labor. So thank you for that. And I thank all of you for the great work that you continue to do to serve our Texans. So thank you.
Right. Yeah. Well, Commissioner, very, 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 very little in life is certain. But you can always have great certainty that you 100% had a positive impact on the lives of hundreds of thousands of Texans. And no matter what else happens, that happened. And I think you can take great pride in what you've done there. And nothing in life is permanent. Each adventure gives way to a new adventure. And I think all things have their season that gets proved out time and time again. And so you've reached the end of this adventure and you'll embark on the next one. I think what I know to be true is you may not be a part of this commission any longer, but you'll still have plenty of friends here in Austin. I hope you'll come see us.
Thank you.
Thank you.
Chairman, let me kind of echo some of those sentiments, and kind of a bittersweet moment, bittersweet day, but real excited for what the future holds for you, Commissioner Alvarez. And so let me just thank you for the work that you've done, but more importantly, the action that you've taken, and then the results that we've received here in the state, but especially proud of what's happened in the Valley as well. And so a lot of the initiatives that have been pushed forward by you, you're leaving a legacy in that regard. So when you talk about the hireability program, that's something that we didn't have in Cheryl Fuller in her team, but we have that now, and that's forward thinking. And there are a number of other initiatives that have been pushed forward. So we like to say it's not goodbye or so long or anything. We're going to see you soon. but super excited for what the future holds and what you will be able to do from that standpoint with this team and others. But especially thankful for the friendship and the relationship in the Joe's Bakery and Hovos and the many stories that we have and getting the band out there and the like. And it's been a joy and looking forward to the next chapter, as the chairman had mentioned. So thank you for everything. Again, bittersweet, but excited for you and what a blessing, and delighted that you shared the story about your mother as well. And so what a way to end it. So job well done.
Thank you. Thank you.
All right, if no further business, we'll entertain a motion to adjourn.
Chairman, I move that we adjourn.
I guess I'll second that motion. Second motion, second.
Been moved and seconded to adjourn. Any further discussion? Hearing none, we're
No.
adjourned.